welcome to this lecture of the Environmental Law lecture series. I very much welcome our guest lecturer, Professor Nathalie Hervé-Fournereau. Over the years, I really have loved to cooperate with her, and I also really enjoyed her contribution to our research handbook in EU environmental law. Nathalie is an expert on water law, on the Water Framework Directive, which was adopted in 2000. But as you can see and learn from the title of her lecture, she looks into the future and she wants to discuss how to design the future of European water law. That's super important. So particularly 25 years after the adoption of the Water Framework Directive, then to evaluate and to look forward to the future of EU water law. And having said that, I'm very happy to hand over the word, to give the floor to Nathalie. Nathalie, you can take the floor.
Thanks a lot. So good afternoon, everyone. Dear Mariam, I would like to thank you very much for your kind invitation, and I'm so delighted to share with you my reflection of the evolution of the European water law, and in particular on the forthcoming European initiatives on water resilience. The European Commission is expected to present this initiative in June 2025, after it was pushing back from February last year. Its primary response to the call from the European Economic and Social Committee for a Blue Deal, similarly echoing the success of the first European citizen initiative on water, Right to Water, in 2013, a new citizen initiative entitled For Water, Smart and Resilience Europe was officially registered by the European Commission in September last year. My reflection, I try to change the slide. I hope it's possible. Wow.
Yes, it's possible.
Yeah. Okay, yeah, perfect. So my reflection now built on the continuity of my research, in particular, the work I published in the EU Environmental Law Research Handbook edited by Mariam and Mariola. In that contribution, I analyze the 2019 fitness check of the Water Framework Directive to explore the future of EU water policy with a focus on inclusive governance and ecosystem-based protection and management. But my research is also former part of a French national interdisciplinary research program entitled One Water, Water as Common Good, where we reflect on the necessity and the necessary evolution of water governance models, including the reconnection of natural and spiritual entities. In line of this program, the annual seminar of the Environmental Lawyer Network Avoceta Group held last year in my university, and it was dedicated to water law and sustainable trajectory, and it was structured around three key issues: water as common and right to water, but also integrated water management and water biodiversity and water conflict adaptive water governance. A national report from 25 European countries, along with a guiding questionnaire, are available on the Avoceta Group website, and I encourage all of us to explore this valuable resource. As you can see on the slide, I just give the website if you want to explore this different national report. But this afternoon, I would like to share my reflection, and I cluster my presentation into three parts before opening the floor to a discussion. So first, I would like to outline the key issue at stake, their complexity, of course, but how the law has progressively begun to address them. And in second, I will provide a very brief overview of the current legal framework, and highlight both its strength, but also the different limitations, in particular in light of the alarming state of water bodies and ecosystems challenges that are further intensified, exacerbated by the climate change. And finally, I will consider possible development in water protection and management and reflect on the ambition behind the potential Blue Deal promoted by the European Economic Social Committee, with a particular focus on the much anticipated European initiative on water resilience, with a very soon result of public participation engaged by the European Commission. So let's begin for the first question. If I may, I would like to invite you to reflect about your own relationship with water. What does water mean for you? How do you picture it? And what value do you associate with it? And how much do you know about the water cycle, deep connection between different ecosystems? And just another question, do you know where the water that flows from the taps in your home or in your university actually come from? This seeming simple question, but they relieve much more than personal perception. And they shape the way we think about water, our water influence our political, legal, but economic system too. And they expose the nature of our relationship with this essential element, this living environment, and raise a fundamental question: what does and what role does water truly play in our societies and in our legal system? Which brings us to a broader reflection, in fact, to think about which kind of a place water has and is in the Green Deal in particular. We can see. We can observe that its relative absence from this agenda has been noted by the European Economic and Social Committee in several opinions in 2023 and in 2024, concern that led to its call for a Blue Deal. But we'll return to this point in great depth shortly. The construction of legal framework is necessarily influenced by the social, cultural, political, and economic representation of water, but by the underlying value attached to it, whether water is seen as an exploitable natural resource or an heritage to be preserved, or ordinary or extraordinary living environment, or spiritual entity embodying life and spirit. However, this diversity of representation is not always reflected in legal system, revealing a hierarchy of choice and interest that often marginalizes other vision and value, such as those held by indigenous people, for instance. And the growing movement of right of nature and its diverse legal expression around the world, including in Europe, highlight the need to recognize and integrate the social, cultural plurality that shape our relationship with nature, particularly with water and aquatic environment. Legal analysis also reveal the extent to which scientific knowledge specific to water and in interaction with natural ecosystem is taken into account. From the outset, one must recognize the scientific complexity involved in understanding water. For example, different research show us that water and its diversity of form, liquid, solid, or vapor, its diversity of location, surface, water bodies or groundwater, transitional zone, but also coastal water, and not forget the glaciers, of course, which provide for us a very fresh water, important. But also we have to show the diversity and the variability of availability across territories. Of course, don't forget its biological diversity, with aquatic ecosystems that are more or less vulnerable to human pressures, depending on their location. For example, in my region in Brittany, we have very close coastal bay, which are very exposed to eutrophication. It's completely different in our bay of the Mont Saint-Michel, which are very open bay and we can find no eutrophication, no green algae, of course, on the beach. We also much consider various temporalities involved in the water cycle, such as the long time scale required for groundwater research or the delayed response of ecosystem to pollution reduction measures, which may discourage action, in particular action from the farmer. And at the same time, we have short-term events such flood that demand immediate response. An integrated legal approach to this diversity and scientific diversity of water is far from automatic in EU law. It was not until the adoption of the Water Framework Directive that such complexity began to be legally addressed, a text to which I will return just after. And some issues, such the representation of glaciers, are only now receiving heightened attention as awareness of their disappearance grown. In fact, the United Nations, perhaps you know, had just declared for this year the International Year of Glacier Preservation, and the Day of Water was designated this year as World Glacier Days. Of course, numerous very important interconnection between water bodies, river, lake, and glaciers are very numerous and intricate. And a recent case from before the Court of Justice of the EU highlighted the need to account the connection between small lake and water bodies when assessing impact under the obligation to prevent deterioration and achieve a good status. And the land-sea continuum also deserves emphasis. Under the effect of the climate change, sea level rise is already causing saltwater intrusion into coastal groundwater aquifer, and pollution also circulated across water bodies, whether plastic pollution or other form flowing from river to sea, often across borders. And this phenomena underscores the need for a coordination between Water Framework Directive, but also with other legal instruments for preserving biodiversity, but also with the Marine Strategy Framework Directives. So all those interconnections extend beyond water body themselves. They exist between aquatic, terrestrial, and marine ecosystem, but also between water, air, soil. To take into account all those connections is very important, and it is very crucial because air pollution affects the chemical quality of surface water, the degradation of soil biodiversity reduces water retention capacity, and we can see with a growing flood in Europe in particular, and the loss of peatland and wetland diminish their natural function to water regulation, filtration, and habitat provision, of course. And this integrated systemic understanding of water bodies and their close interrelation with various environment and ecosystem is crucial and very essential for building a robust legal framework. Yet, for example, in the case of soils, the European Commission was forced to withdraw in 26 soil framework directives proposal in 2014, and the current proposal for soil monitoring law is still under negotiation. Adding to this complexity is the challenge of scientific uncertainties and knowledge gaps. And sound knowledge of the state of water bodies is vital for adapting legal protection and manage mechanism, and for developing future scenario to anticipate pollution or risk of degradation, particularly under the climate change process. However, the last implementation report of a Water Framework Directive this year highlight ongoing data deficiencies, despite notable progress in improving knowledge, and in some member states, a significant percentage of surface water bodies remain unclassified due to lack of data. In conclusion, legally addressing this complexity is not an easy task, It requires us to move away from seeing water merely as a static resource, a fixed quantity available at a given point in time, and to think in terms of flow dynamics. It also demands that we confront unpredictabilities and uncertainty, as illustrated by the tipping point emphasized by the report of IPCC. And furthermore, it's called for us to a reflection of the value we want to attach to water and the social and economic model that underpins those values. At one end of the spectrum lies an anthropocentric utilitarian vision, water as a renewable, infinite, and appropriable resource, something that we can store, trade, and regulate by market force and profit mechanism. And this vision of sustainability is closely linked to economic models that treat waters as a measurable resource that can be allocated by quota, transfers across basin or border, or replaced with reconstituted drinker water when natural sources are so contaminated. And the other hand, we have more ecocentric conception with assigned intrinsic or inherent value to nature, as advocated, for example, by the movement of right of natures. So, where does EU water policy stand in this spectrum? The Water Framework Directive said, I try to change. Yeah, I just give you a very few detail of this slide, just for you to show the different pressure related to water pollution, but also a different form of degradation. It was in the last report of the Environmental European Agency, but also in the report published by the Commission related to the implementation of the Water Framework Directive. We have to try to imagine which kind of vision the EU law has of water. And if we have a look on the Framework Directive, we have some information. The Water Framework Directive set a clear tone from its first recital. Water is not a commercial product like another, but it's a product, but rather an heritage which must be protected, defended, and treated as such. This dual language reflects a nuanced utilitarian approach framed by the general interest, but also introduce a patrimonial dimension. Different member states reflect this in their national law. France, for example, recognizes water as part of a common heritage of a nation and consider its protection, enhancement, and sustainable use to be matter of general interest. While the Water Framework Directive does incorporate an ecosystem-based perspective, this approach remains somewhat overshadowed by the patrimonial and utilitarian framing. Still, its primary objective, very important to note, no. Yeah, okay, yeah, it's perfect. I just want to insist and to focus on the first objective of a Framework Directive related to the ecosystem-based perspective. The first objective of this directive is to prevent further deterioration and protect and enhance the status of aquatic ecosystem, and with regard to the water needs, territorial ecosystem and wetland directly depending on the aquatic ecosystem. However, the EU law not yet fully embrace the right of nature approach, despite growing academic interest in that direction, and member states are more or less free to pursue such path. It was the case in Spain with the Mar Menor case, which was recognized in 2022, the legal personality and different natural right. But we will return to this aspect just after. So if we have a look at the beginning of the EU law policies in related water law, we have to observe that it is very fragmented and reductive approach to scientific complexity of water. The beginning of this policy was completely a sectorial approach and do not take into account the global cycle of water. And different legislation was adopted in function of, for example, water at stake, water surface, groundwater surface, bodies, etc. Or it's depending on the human use, drinking, bathing, fresh water for fish life or shellfish, or it's depending on the type of pollution, dangerous substance or nitrates or urban wastewater. But also it's depending on the source of pollution, agriculture, in particular nitrates from agriculture sources, but also pollution from urban wastewater installation. This first generation of EU legislation of water was really focusing on water pollution. Of course, it was a reaction to the situation existing in different member states, but also it's depending on the EU competencies. And if we have a look in the treaty, according to the title of environmental provision, we have to observe that it was specific procedure to decide and to adopt measures affecting the quantitative management of water resource or affecting directly or indirectly the availability of those resources. And it's obliged the community and the EU, if it's want to adopt decision on the basis of unanimity of the Council and only consultation of the European Parliament. And I'll just give you an information related to case law. It was about the Convention of Danube River, and it was about which kind of legal basis to adopt a decision to approve this convention in the EU law. And another explanation and observation connected related to this first generation of EU legislative related to water law. It was very limited connection with other environmental legislation. I can give you three examples, in particular directive related to bird and natural habitat, of course, and directive related the directive. But it was very few connection in this first generation of EU legislation related to water issues. And of course, insufficient integration of water requirement into the other policy, despite the principle of integration of environment requirement into all the policy. And of course, directive and the Water Framework Directive is really a paradigm shift compared to this first generation of legislation. It's a cardinal directive, we can say, and we can use this expression, just because this directive completely restructures existing water policy and legislation and abrogated some of them. This directive established explicit links with other water directives, which are not abrogated, and other legislations more explicitly with, for example, the Natura 2000 network. In this directive, it's mentioned to reinforce, to enhance the further integration of environmental requirement into EU policy, in particular water requirement into all the different policies. And this directive focuses on a better holistic and ecosystemic approach of a water cycle, as we see just before related to the scientific data. This directive takes into account not only sort of this type of water, but it's really an integrated approach, taking into account surface water and groundwater bodies, but also the continuum land-sea, to take into account inland surface water to coastal water. And it's very interesting to see that the scale of river basin is adopted and to take into account, of course, transboundary dimensions. And quantitative approach is also mentioned, but only as, I will say, to help and to answer the quality of water. But it's because if we have really provision of quantitative aspect, as I said just before, the question of the share of competency will be very difficult. So it's just an ancillary aspect related to quantitative approach for groundwater. And of course, another thing very interesting compared to the scientific knowledge, just during the first generation of EU water legislation, it was very focused on chemical pollution. And with the Framework Directive, we have to take into account not only chemical pollution, but also the question of ecological element, but of course, hydromorphological element to try to understand the different pressure related to the water cycle. Another observation I would like to say and to make also, it was the Green Deal. Of course, the Green Deal, everyone now the Green Deal and wondering about its future. But when it was very wonderful dynamics when we adopt the Green Deal, what about the water in the Green Deal? And as you can see, no mention of water issue, except in some strategy related, for example, the zero pollution plan related pollution to water, of course, but there are no dedicated EU water strategy. Despite this absence, thanks to the Green Deal, we have different process of revision of water EU legislation. We will see just before, and of course, the Green Deal is its ambition is to transform the EU economy, and so its need to reinforce, to enhance the integration of environmental objective, but also water objective into all the policy. And we need to focus, of course, on the current actualities related to water at the international level with the water conference in 2023 related to water. The last conference, international conference, was in 1977. So it's completely interesting, illustrated the way we think water and we think about the crucial issue of water. Really, perhaps we consider now that's water emergency, it's at stake. And we have different reports, in particular the report from the IPCC or the recent report of the APPS, which focus the question of water related to climate change and biodiversity, and to find together these three crucial crises, in particular to observe the situation related to water issue, not only quality issue, but of course, a quantitative issue of water. And we have a report of a European agency on water issue last year, and different scientific, a particular scientist from the Stockholm Resilience, they show us that now the planetary boundaries related to water has already been crossed. And it's very interesting to combine this this scheme of planetary boundaries with the donuts, the economic donuts, to see how it's very crucial issue to think not only in the side of limit boundary, planetary boundary, but also to take into account the social and cultural aspect of this water emergency. So I invite you now to switch to the second point of my presentation. It was a brief presentation of current EU water framework to show you how it's very strong, very interesting framework, but to show also the difficulties of this EU water legal framework, and to think why we need to think to go beyond this current legal framework. Of course, as I said just before, the Water Law Directive is very substantive body of water law, with ambitious objective and time schedule. We have to achieve a good status of all water bodies by 2015, and based on a very strong approach, one out and whole out. If we have one element, ecological or other, not good, all the elements are considered are not good. So it's very, very strong approach. And in this directive, it's not only a good ecological and chemical statute, but also good quantitative statutes for groundwater, and it's introduced an expression of good ecological potential. I don't want to go into detail, Marian, but just to see very briefly the importance of this legal framework. Oops. As I said just before, it was very a complete directive, but very technical directive, with numerous annexes, and it's obliged and enforced the Commission to adopt a lot guidance document to help the member state to implement this directive. And we find in this directive several provisions, not so clear provision without definition sometimes, and it will be open to interpretation in member state. And of course, it's provide case law and different litigation before the court. But we have also case obligation on member state. I give you just an example of very key specific obligation on member state. The characterization, of course, of water bodies in order to improve the data and knowledge on the state of water bodies in their different territories, but they are obliged also to adopt a river basin management plan and program of measure. So actually, the member states are normally all, but it's not exactly the case, they normally have adopted their third river basin management plan. And it was the reason why the Commission in his report this year found some deficiency of member state because some was so late to adopt the third river basin management plan. They also have to take into account different legal environmental legislation, in particular related to register or protected area. Of course, it was Natura 2000, but also the vulnerable zone identified by two directives, Nitrate Directive or Urban Waste Water Directives. Among the different obligations of member states, very interesting aspect to observe, it was provision related to the economic analysis of water services and the principle of recovery of the cost for water services in light, of course, the polluter principle. But in this directive, the member states are very free to decide the tarification of water services, in particular to take into account vulnerable population and to think about a social tarification of water. Another aspect I would like to focus on, it's the question of governance provision in this framework directive. In my contribution to the book for Marian, I insist I focus on this aspect because if we see on this directive, there are few provisions related governance and democratic, in particular democratic aspect. thanks to the court, I will say, the court conclude that it is an obligation. It's not only to encourage, it's not a non-binding obligation. It's really a binding obligation to encourage the active involvement of all the party interest, but also public in the light of Paris Convention, of course. I just give you in this slide a presentation of different transboundary cooperation and international river basin. We have, it's around 60% of this river basin management we have international dimension. But this directive has a provision which cause main problem, in particular in terms of litigation problems. It was the possibility for government states to accept a less stringent environmental objective or to require exemptions and deadline extension, because normally the directive provides that all water bodies need to be at good state in 2015, but we are now 10 years after, and we have to consider that this objective is not achieved. And it was this provision related with the possibility for the member state to adopt less stringent requirement or to adopt and to propose exemptions is very, very a crucial aspect and controversial aspect, because it's very open to interpretation and it leads to litigation. Of course, as it was exception, thanks to the court again, they always said we need to have a strict interpretation of such a provision to not respect the main objective of a good state of water bodies. I don't want to go further in this detail, Marianne, if you agree, because it's just for the presentation to see how this provision are written very, very in complex way and open to discussion. Of course, in this directive, we have a possibility to allow member states under strict condition to reach the good status of water law only in 2021 or in 2027. And now it's very important to observe that many of member states do not already achieve this objective 2055. And what could we expect after this date of 2025? Sorry. Just a very short overview of the different. I tried to organize the game, but it was completely. It's a way to show you the complexity and the necessity to interconnect the different environmental legislation related to water issues. We have, I don't want to go further into the detail, but it just to show you the different possibility to think not only the entire water cycle, but this water cycle with the other environmental element and compartment to think and to focus on this integrated approach and ecosystemic approach. And I have to just to give some information related to the efficacy and the efficiency of this Water Framework Directive. It was, but I invite you, if you want to have more information, to read my publication for Marianne on this topic, because this fitness check of the Water Framework Directive and the Float Directive conclude that both directives are very well fit with some scope to, but they need to reinforce or to keep in mind some difficulties related to the implementation of this directive. Of course, the insufficiency related to the implementation by member states. We have lots of case law. Of course, again, the integration of water requirement into the other policy, in particular agricultural policies, but also the question of how to find much investment and supporting support related to the implementation of such a directive. As I said before, we have lots of litigation before the EU Court of Justice. The majority of the case was a case related bringing infringement proceeding against member states. Three directives are in the top of this litigation. Directive related to nitrate from agriculture, but also Urban Waste Water Directive, and now the Water Framework Directive, of course. This litigation is very interesting because we have a lot of cases related financial penalties on member states, and it's completely different in other field of environmental legislation. So it gives you an illustration of the crucial issue and the difficulty to implement and to respect the legislation. I'll just give you some picture to see the protest of NGO against, for example, basin, a big reservoir of water. And another picture, it's very interesting. It was the case, the litigation between Czech Republic and the Republic of Poland related this mean of Douro and the impact of the groundwater of this mean. I just find it was very interesting. It's a picture from Copernicus to show the difficulty of this aspect, and invite us to think about the future mining project in Europe. And the last thing I want to show you related to the implementation of this directive before to go to a Blue Deal is added pre-value. It was a report of a very recent report of the Commission. And as you can see, it was a very few percentage of surface water bodies which appear to be in good state, good ecological state, or it was the same relative to chemical status of surface water bodies. So it's very worried it's obliged us to think how it's possible to have a very strong legislation and so poor result on the ground related to implementation of such legislation. And I just give you another information very strange when I discover the report. It was the case of the unknown chemical status of surface water. And if you see 3 member states, they explain on their report the high number of unknown data was amazing. In particular for Denmark, it was amazing to see such information. It was strange too to see the result related quantitative good status of groundwater. If we compare this number to the growing water scarcity and stress water in Europe, it's very interesting to see the difference of these two aspects. And in all the reports of member states, they all say, or most of them say, it was not possible to respect the objective of good status of our water bodies in 2027. So another information, but I just want to go further. It was different information to identify with kind of difficulty we have to be face. Of course, the question of data the difficulty to obtain results because, as I said just before, the ecosystem need time to recover their health. So it's difficult to obtain in a very short time very interesting result because it's due to the so numerous years of contamination, of degradation of water bodies. Okay, I go further too, because I want time to discuss and to see, to present you the Blue Deal. It's just some maps to see the situation. So it's always very worried when we see such a map. And again, it was interesting, but in this report, we have now a map related to the aspect of quantitative aspect more and more because we have faced into difficulty to related to the availability of the water, not only in the south of Europe, of course. And now, what about the Blue Deal and the EU water resilience strategy? It's like when we invite some friends to have a big dinner, and you always prepare many things. So I'm in this situation to have prepared so many things for you, but I need to go more quickly if I want to discuss with you. So just the genesis of this question, a Blue Deal. This proposal comes from the European Economic Social Committee. It was in 2024, this committee decided to produce many and several own initiatives, own opinion initiative. Very interesting. I give you the list of this own opinion, and there are also two other opinion ongoing actually. But it's a way to take into account different aspects of water challenges related in particular to the growing impact of climate change. Based on this different opinion, the committee decided to address letters to the Commission, to invite the Commission to adopt a Green Deal. It was not only the committee, it was also the European Parliament, member of European Parliament, but also member of a region committee to push the Commission to make something due to the crucial aspect and dimension of water issues. And it was very interesting to see also that the committee adopted a declaration. And this declaration was not so long, but put together different aspects, structure on 50 principles. As you can see, these principles are related sometimes to the question we just see before, in particular related to the human rights, but also to the restoration and protection of ecosystem, but also the question of how to organize more sustainable consumption of water, etc. And it lists different actions to adopt as a matter of urgency. And different action related to data, related to how to imagine a common approach related design of water price, etc., related, of course, how to promote more sustainable use of water through labels of product, or to organize and to promote different research and innovation to be more sober related water use. So and the last action the committee proposed was to have and to design an EU commissioner to be in charge of water portfolio. Now it was the case. It's interesting to see that the new commission, and for the second term of Ursula von der Leyen, we have now a commissioner in charge of environment, water resilience, and competitive circular. So it's a sign, or it's a very interesting signal to see that it could be now a top priority of the EU. And this different call of the committee is echoing through civil society. And just give you very quickly the presentation of this European citizen initiative for water smart resilient Europe. This initiative is actually ongoing to collect different signatures. And its objective of this initiative is very in mirror of a proposal of a committee to promote holistic and strategic action plan, etc., etc. It's just a summarize of this initiative and the aim of this initiative of citizen. And now the response of the Commission. The first, actually, we do not have a strategy, a EU strategy. As I said just before, the Commission will present it in June. But the Commission decided this year, this beginning of this year, to organize a consultation call for evidence. And it's very interesting to have another view of this call for evidence and to see the different feedback. We have two, in fact, call for evidence, once for water efficiency first and European water resilience initiatives. And I decided to go further and to read all this feedback, and very interesting to see the different parties, the different way to think about this initiative. And the specific in this call of evidence, the Commission gives a very brief explanation related to this future initiative, and they precise that this initiative needs to have a three specific objectives: to restore and protect the broken water cycle. So it's very interesting to see the necessity to better understand and better take into account this water cycle. Ensure clean and affordable water and sanitation for all. So it's really connected to human rights approach. And the last one is very, I don't say it's strange, but it could be open to diverse and controversial interpretation. And just before I will give you my opinion on this project, it's very interesting to note that the Commission explicitly precise that this initiative will be only a communication, not produce new legislation. So it's really like a strategy, biodiversity strategy, or a zero pollution plan. And another thing is very interesting to note in this very brief presentation in this call of evidence, no mention of Blue Deal. No mention of Blue Deal. This expression is completely absence of this draft of the Commission. So, what about which kind of observation I want to share you just before the discussion? Is it really a paradigm shift? Are you very facing to a new paradigm shift of water legislation and water policy? If the Commission not mention the Blue Deal expression, I think it's very a pragmatic approach. I just propose bluing the Green Deal, in fact. More take into account water issue in the Green Deal, because if we have two blue and green in my country, in my region, blue and green, it's a color. We can put together these two colors, and in Britain we say glass. It's a color. blue and green. And I think it's the best way to think because it's so the best way to avoid a contradiction in incoherence and confusion if we have two deals different. And the blue and the green deal, as I said just before, we have different revise or adopt new legislation adopted, taking into account water. So we don't have to put away the Green Deal and to push forward a Blue Deal. We have to think together. But of course, we have to take into account the failure and the threat to the Green Deal. I just gave you some examples. It was a question of the glyphosate, the renewable glyphosate authorization, the failed legislative proposal of pesticide, the absence of presentation of rich regulation revision of the postman of deforestation regulation, and of course, omnibus package. So it was, I think, we have with this future initiative, we have positive aspect, but we have also negative aspect. I give you some example of a positive aspect. The positive aspect is to take into account water cycle-oriented approach and answering protection and restoration, of course. Human right approach, we have to reinforce and perhaps to go to reconnection of right of water. Another thing very interesting, and to put the question of water issue at the top and as a cross-cutting priority, and to think with a nexus approach and not only integrated approach of an integrated water issue in different policies. So to think about nexus approach could be very interesting. Another thing could be very interesting if we need, and we have to need to enhance the financings of water issue investment in the line of to do no significant arts principle, etc. But, and I will finish by, yeah, I try to respect the time. Where and which kind of negative aspect, and we have to be very vigilant to this. To be aware of this negative aspect of this blind spot of this future strategy. If we have a look on the Commission framing of the call, no mention of the necessity to recall that water is public common good and not a commodity. No mention also, and we have to be very attentive to the need of nature and ecosystem. Of course, no mention of right of nature. Another question, very questionable question, is the water efficiency first principle. And the Commission gave no definition, but it very, very questionable, this principle. Why it would be the first principle of the water resilience strategy of the EU. It's very controversial. Another question is the focus on water management, less than on water protection. So we have to be very vigilant related to this aspect. The question of exemption related to Water Framework Directive post 2025-7, we have to be very aware of the risk of a potential Pandora box or revising this directive. And I want to focus on the question of democratic governance and inclusive governance. And perhaps you have in mind the different protests in France related, as I said just before, basin, and water reservoir and different protests. And we have the United Nations Reporter of Environmental Defender. We last year explained that French authorities do not respect the defender of environmental issue. So it's very important to keep in mind that if we want to protect water, we have to protect also defender of water issues, in particular in face of the growing conflict related access to water and sharing and how to share water. So I hope I try to go fast. And many thanks for your attention. Thanks a lot.
Thank you so much, Nathalie. Thank you so much for this amazing lecture. We have many students here in the lecture hall, and I can imagine that they feel completely overwhelmed almost with the complexity actually of how to protect water with law. But I hope they also feel very motivated by your encouraging talk about showing how important it is to protect the waters. So thank you so much for this, and I would like to invite students for a big applause for you.